The next case is in re adoption of T.D.A. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please keep your voice up, remain behind the podium, and introduce yourself. You should not use the names of children, minors, or victims in your arguments. You can refer to them by initials or terms like the child. I also understand that there's a pending motion here. You can incorporate that into your arguments as well. We have read your briefs and are ready to proceed when you are.
Good morning. My name is Gary Gottfried. I'm here on behalf of the appellant, and I would like to reserve 3 minutes. Before I begin, Your Honor, I'd like to take a moment to mention one of the cases that we cited in our supplemental authority, EAKM. That was reversed by the Ohio Supreme Court about 4 days ago. And I wanted to bring that to the court's attention. Having said that, I do want to state, though, that for the proposition of law that we used in that case, we still think that that's valid. As we start talking about this case, I do want to say that my client appreciates the efforts of Judge Stormer. She's a fine jurist. We're not here to disagree and disparage her. We believe that Judge Stormer attempted to achieve equity. We're not arguing about that. But we are addressing the fact that although Judge Stormer attempted to arrive at an equitable solution, she has to do so within the framework of the law, and we believe in that case that she has not done that. We believe that in this particular case, Judge Stormer's decision is flawed on several reasons. One is on a due process argument, and the other will be on the issue that the trial court exceeded its jurisdiction. Excuse me. So I'd like to start with the issue of what took place. In this particular place with regards to the due process argument, this was a case, as the court knows from reading the briefs, that addressed the issue of whether or not a step-parent adoption should go forward. That was the only issue. In fact, that issue was even more narrowed to the extent that the issue became whether or not the appellant could be allowed to withdraw what the court characterized as her support of the adoption. And as the court knows, the trial court magistrate found that, in fact, under the statute, the appellant could withdraw her support of the adoption and dismiss the adoption. Appellee then filed an objection, no issue about that, filed a supplemental objection. And what is important to note as we start to walk down this path of due process is that all that was presented to the trial court, was the argument whether or not consent and support, consent to the adoption, support of the adoption, meant the same thing.
Isn't a threshold issue, though, whether the person is a step-parent?
Well, I think that Judge Stormer kind of stepped over that. Judge Stormer said, if you read through the rest of her decision, what she really said was, you don't need a step-parent adoption because you, appellee, are a parent, and we disagree with that.
So doesn't that infer that the person is not a step-parent, and in fact a parent?
Well, I think that's some of the substance of the argument that we're presenting, and the fact that Judge Stormer's analysis to get there is flawed. It's flawed for a number of reasons. Number one, Judge Stormer cited several Ohio cases. And remember that she says this is a case of first impression. She could not find any legal precedent to find appellee as being a parent. So what does she do? She looks at a couple of other cases. The cases that she used were Ohio cases, and then there was a Michigan case. The Ohio cases have nothing to do with this situation. The Ohio cases either involve where visitation is granted to a non-parent, we're not arguing about that, or it's where a father comes in and says, I am the biological parent. Once again, not a situation here. And then Judge Stormer then reaches...
Isn't the most analogous scenario though surrogacy here?
No, I don't think so, Your Honor, because see, here's the problem with the surrogacy issue. That's a contractual relationship between two people and a surrogate. We don't have that here. I wouldn't be here arguing if we had a surrogacy. I think that would be some way, although as I understand it, even in that situation, you have to create some link between the child and the, so to speak, the parents. But to get to your question in particular, this is not a surrogacy situation. It's not analogous because there's no contractual underlying relationship between the parents, if you will call them that, and the surrogate. That doesn't apply. But what Judge Stormer did is she kind of reached out to this case from Michigan. And she kind of said, well, see, this Michigan case gives me the authority. But when you read that Michigan case, Lefevre, I think it's called, there is a significant distinction when you read that case. Excuse me. And the distinction is this. In Lefevre, the defendant carried the child. In Lefevre, the court, the Michigan court, stresses the fact that the mother in this case was the birth mother, uses those phrases. That didn't occur here.
Counsel, does it matter at all that the appellant here executed an affidavit related to the birth certificate and putting the appellee on the birth certificate? What is the effect of that?
Well, that's an interesting question. I kind of thought you might bring that up. Here's the problem with that line of reasoning. The probate court is a court of limited jurisdiction. I don't know that anybody would dispute that. And when you read the statute which establishes what a probate court can do, one of the things a probate court can do is entertain adoption, no issue. But when you read the 32 different causes of action that are in that statute creating the probate court's jurisdiction, there is no mention that a court can determine the parent-child relationship.
But isn't that presumed? If it were not a same-sex couple and there was a father written on the birth certificate, there would be no court action. There would be no action for parentage needed. It would be an automatic presumption of parenthood.
Well, you may be right, but here's where I would disagree with you. You're in the wrong court. The probate court can't make that determination. I wouldn't argue.
So if you were a father on the birth certificate and somebody was contesting that you were actually the father, what court would you file that in for parentage?
I think you file it depending on the size of the community. I'm from Franklin County. We file it in the Domestic Relations Court, Juvenile Division. I'm not disagreeing that someone can come to court saying, I'm on the birth certificate, I should be declared to be the parent. That's not my argument. My argument is you're in the wrong court when you ask the probate court to make that determination.
But that wasn't what was going on here, was it? It wasn't. Doesn't the probate court have a right and duty to determine its own jurisdiction and whether the appellee properly fit into the class of a step-parent adoption? Isn't that really what happened? That's firmly within the jurisdiction of the probate court.
I don't think it is, Your Honor. I don't think that the probate court, first of all, let me say, I agree with you. A court can't determine its own jurisdiction. That's not the issue. The issue is it can't confer jurisdiction upon itself that doesn't exist. And that's where you and I would have a disagreement. What I'm saying is this. If the court says, i.e. the probate court, we have an issue here of whether or not this birth certificate is presumptive of parentage. I don't think the probate court can make that determination. What should have happened in the perfect world that we all practice in.
What about step-parentage?
Well, that's
Determination of step-parentage.
See, that's within the statutory guidelines, excuse me, of the probate court. I'm not arguing that. There's a distinction between creating, having what we call a step-parent adoption, where a parent comes in and says, I would like to establish a relationship between myself and the child. I am not arguing that.
But wasn't this dismissed by the probate court based upon her not being a step-parent?
That's absolutely correct, and that's the problem, which gets us back to this whole issue of due process. That was an argument that was never raised by the trial at the time of the trial court at all. In other words, this argument that this finding by Judge Stormer came out of left field. It was never discussed. There's no evidence about it. It just shows up in her decision. And so you have this whole due process argument, which is where I had started, in the sense that you can't expect somebody to respond when that's not even on, to use a phrase, on the radar. The judge just went and made this decision with regards to the fact that she found that the applicant was a parent. And then you get down to this other argument being that her decision is flawed. It's just flawed, and I think she's trying, and I respect Judge Stormer. She's trying to do equity. I understand that. But you can only do equity when you have, when you're within the guidelines of the court.
So, I'm sorry, go ahead.
My understanding is there was a divorce with children filed.
That's true.
Your court, do you think that's the appropriate jurisdiction for them to hear this particular issue?
Absolutely.
In that case, it stayed pending this case?
Is that a question
Yes.
to me? No, actually, from what I understand, that case not only did not get stayed, it proceeded to trial last week. So now, we have this real potential problem coming up, depending on the outcome of this court. But to answer your question directly, it's my understanding, counsel and I know each other, that in fact, it went to trial. Whether or not there was a request for stay, I'll be candid with you, I was not involved in that. I think I'm getting close to my 3 minutes. So I would just like to finish up, if I can, to the second argument, if I can, and that is this, and we touched on it before. The probate court is a court of limited jurisdiction. It can't go outside of its limited jurisdiction to hear other issues. And we cited cases where the court couldn't hear, probate court, money damages and things like that. This is the same argument that we have here. The court did not have the authority to determine a parent-child relationship, and that's what it did. Effectively, Judge Stormer declared that the appellee was a parent. Now, I'm not arguing that a trial court could not find that, but you're in the wrong court, i.e. the probate court. It has to come through another division, such as the juvenile division or the domestic relations division. Thank you.
Thank you, Your Honor. Christopher Reynolds for Heavily. I'd like to touch on two issues, both related to standing. I'm going to take them in reverse because the discussion that was had during Mr. Gottfried's presentation hits on the second one, which is whether or not my client had standing to bring the petition for step-parent adoption in the first place. Judge Lanzer, I believe you raised the question initially, which is, doesn't the trial court, in this case the probate court, have the authority and in fact a duty to determine whether or not somebody that's trying to invoke its jurisdiction properly meets the criteria of a proper petitioner? I think that's exactly what Judge Stormer did.
Could she take it as a concession that her client is a step-parent because that was conceitedly filed by her, a step-parent adoption proceeding?
I don't.
Should she be considering that if it seems to be a stipulation of some sort by the filing of the petition?
I don't think she's bound by that. I don't think she's ever necessarily bound, especially on issues of jurisdiction, especially on issues of standing. As we all know, standing can be raised to address one of the arguments my esteemed colleague raised, is that when we're talking about subject matter jurisdiction, of which standing is just a subset of it, it can be raised at any time. This court could have, if nobody had raised this issue at all and our side had appealed, we could be here and this panel could say, I don't know that your client had standing to bring the petition in the first place.
But then would we go on to declare the person a parent? Because that has certain rights that accompany that.
And I take issue with the focus on, I'm sorry, go ahead.
Or would we just, or would it have been proper for the court to just say this person is not a step parent, period?
I think she could have done either. I think we're getting, the appellees hung up on the use of the term declaration of a parent and getting hung up on semantics. I don't think that what Judge Stormer did was adjudicate anybody the parent. She was merely making the observation of the legal impact of operation of law of my client on facts that were already established by the time that case got to her court, not just in front of her, but by the time the petition had filed. So when the court is determining whether or not this person is a proper petitioner, whether parties agree or otherwise, it's sort of the analogous or corollary of you can't confer subject matter jurisdiction on a court. You also can't confer standing. So if the trial court judge says this person doesn't have standing, now it could have been under what the appellee would have preferred, which is she doesn't have standing because his client removed her support for the adoption, or something more fundamental, which is she's not a step parent. The trial court isn't bound by what the magistrate finds. She can make the determination on whatever basis she believes is proper. Mr. Gottfried mentioned that there was nothing presented to the court or in the record that would allow her to reach that conclusion, which is patently not true. Exhibit 5 was the child's birth certificate, which was admitted without an objection. So the court taking notice of the fact that my client's name is on a birth certificate that at the time was 5 years old is more than enough the court to determine whether under Ohio law, Florida law, whatever, whether or not it is a final determination on parentage. There's cases from Ohio that say just that once you sign an acknowledgement of paternity and it's not been rescinded, it's a little bit more strict in Florida. They only have 60 days, whereas here the outside limit is a year.
Was it fair though that nobody got the opportunity to argue this with more evidence? Because there's clearly some issues that are different than other cases.
I think it is, yes, absolutely, because trial courts and indeed appellate courts all the time will raise issues sua sponte when determining the resolution of disputes, whether or not they're raised by the parties. So this isn't which is, the attempt is to characterize this as almost like an ambush by the trial court on Mr. Gottfried's client, when and the framing of it is that we didn't raise it on objections, we didn't raise it in supplemental objections. It wasn't a claim that was raised to determine parentage, which I agree. Nobody could have raised that question in front of the probate court. It's not a proper court to hear an affirmative claim to determine parentage outside of things that are irrelevant to the facts in this case. But that is not the same as the court determining its own subject matter jurisdiction, or the exercise of its subject matter jurisdiction by virtue of standing and saying this particular person is not a proper petitioner. The fact that maybe everybody overlooked it, I think is irrelevant. It's not a due process problem. It's just a fundamental flaw. Just as the court had, if nobody had raised the issue of subject matter jurisdiction, but the trial court had decided it didn't have subject matter jurisdiction and nobody raised that, I don't think anybody's in a position to argue legitimately that it overstepped its bounds.
Was this actually argued and there was a hearing on this or a trial on this in domestic relations court already?
On the parentage issue?
Yes.
I was not part of the actual trial. I know that the issue was squarely before the trial court. The hearing took place over a course of, I believe, 5 days. It concluded last Wednesday. And oral arguments were made in closing. No, as far as I understand, there's no post-trial briefing. So as I stand here right now, I can't tell you that it was affirmatively raised and argued. It was certainly live before the court in pre-trial, and I'm presuming at trial as well.
So the ultimate decision on whether parentage exists, we could have two rulings in two different courts.
It could, yes, but I don't, to answer you to the predicate of the premise of your question is that Judge Stormer actually made a determination. I don't think she did. She didn't make a binding determination. My client couldn't go and take the probate court order and say, like, look, I'm the parent. The effect of this order, and this goes to the issue of standing for appellee here, is that, and this is the subject both of some of our, certainly of our motion to dismiss, as well as some of the substantive responses, is that appellant got the result that she wanted from the trial court. That's all Judge Stormer's order does. It dismisses the petition. It does it on different grounds, but the substantive relief that she's granted is dismiss this petition. She filed a 12B6 motion to dismiss, which is the proper motion, challenging my client's standing as a proper petitioner. Now, they were focused on the support, consent, whatever we want to call it, and not this other piece, but the challenge was she's not a proper petitioner. That's the relief that was granted. She hasn't been aggrieved in a legally cognizable way from that decision. She doesn't like the words on the page, but they don't have any substantive legal effect. They don't change the relationship between her and her wife. That relationship, as vis-a-vis the child, was established when they signed on the acknowledgement of paternity and had been in place up until the hearing, until this day actually, but at least until the hearing before the magistrate and probate, for 5 years, thereabouts. The trial court didn't really do anything other than acknowledge these are the facts, this is the legal implication of those facts as it relates to standing, and dismissed it. When she tries to make an appeal, she hasn't been harmed. She was granted the exact relief that she was requesting. The arguments that she's raised that there was some sort of collateral, what was the term that they used, that there was a collateral interest in the subject matter of the proceedings, there was no affirmative claim. The case that was ultimately referred to as the US Supreme Court case that talks about class certification. So there was at least two issues in play in that litigation. The substantive claims, and then whether or not the parties were properly representative of the class. They won on the substantive claims for the named party defendants, but the court denied the class certification. US Supreme Court said, yeah, you have an interest in the additional denial of the class certification because that carries with it all sorts of remunerative and other rights that are affected. There was no other claims here other than step-parent adoption. So the attempt to sort of manufacture and shoehorn in, I have an interest in the language on the page, the Supreme Court also, US Supreme Court has also spoken about, which is just because the lower court decides something in a way differently than they might have, they're not in a position to second guess it as long as the result was in favor of the party who's trying to appeal it. It kicks the leg out from their ability to have standing to appeal. That is exactly what happened here. Ms. McGuire fully and completely obtained the relief that she sought by her motion to dismiss. She disagrees with the grounds upon which it was done, but she got the relief that she sought. There was no other claims. There's nothing else collateral to the judgment. in fact, and I'm going to pivot here just a moment, the argument that the appellant has made that there was I think they use the term, the court exceeded its jurisdiction. I've never really been able to square the circle on what they're talking about. Are they talking about exceeding their subject matter jurisdiction? Is it an improper exercise of jurisdiction? In either way, I think it touches on the fact that if a trial court, whether it's a probate court, common pleas court, any other court in the state, even probably municipal court, judges have an authority to take notice of the laws that relate to the facts that are in front of them. And if Judge Stormer had what was stipulated as a valid acknowledgement of paternity before her, and is permitted to apprise herself of the impact of that under both Ohio law as well as Florida, where the acknowledgement was entered into. The revised code requires courts to apply full faith and credit to the final determinations of other states. Right? It's a non-controversial legal premise that we all rely on. The fact that under under Florida law, that acknowledgement of paternity was final, I don't think there's anything improper about her taking notice of that and making a determination that I don't know what we're doing here. I can't allow a non-step parent to adopt a kid, which is more fundamental than simply somebody took away their support of it. And dismissing on that grounds. I think she's well within her discretion, in fact, her duty to determine that, so that way she's not running afoul of her own constitutional responsibilities to only adjudicate live cases and controversies. There's just no case or controversy because somebody lacks standing.
But counsel, you don't look at this as a declaration of parentage.
No, it's acknowledging what the judge believed, whether rightly or wrongly, was the basis. But she did it in service of determining standing on part of my client. The relief that she granted, the only import of that decision is that the petition was dismissed. That's it. That's all it can be used for. Nobody can go wave it around and say, like, look, I have this order from this court that says X. I don't think it carries any sort of legal weight in that respect. So while I understand that—
It was essentially dicta?
Essentially dicta, right? Like, while I understand that the appellant may be personally feeling aggrieved by the language on the page, for whatever reasons, it doesn't have any legal effect.
If there was no appeal or the appeal was dismissed, you don't think that Judge Stormer's opinion and decision would be taken to the domestic court and say, hey, you can't make a ruling on this because it's been already declared?
Like, is it a collateral estoppel issue? I don't believe so, no. I think the domestic relations court is squarely, or juvenile court, in this case it was the D.A. court, they clearly have both subject matter jurisdiction to determine parentage. So if they disagree, I don't think they're bound by it. Does that mean that they can't look at the same reasoning? I think they're certainly free to do that, but I don't think they can rely on it. They're not bound by it. There's no collateral estoppel there saying that the issues are res judicata and they can't be relitigated.
So if somebody was claiming to be the genetic father of a child, where would they file that action for parentage? Would that go to D.R. court or probate court?
In Summit County, it would go to D.R. court because they've combined those functions in the D.R. court, but in a lot of counties, it's either the juvenile or the domestic court.
Okay. So there is no, in Summit County, there is no, they're both common pleas,
yes.
different divisions. There is no way the probate court has jurisdiction to determine parentage. It would always be found by the domestic court.
I think there's one exception in the probate, which it has to do with post-mortem determinations of parentage for purposes of like descent distribution. So I think that they do have a limited carve out for determining, and that's why I said earlier, like the facts in this case just don't, implicate that very narrow exception. When you have two living people that are having a dispute over parentage, yes, it's some division of the common pleas court that would have the final say on what the issue is.
Thank you.
All right, thank you.
You'll have a little over 2 minutes for your rebuttal.
I'll talk fast. I think the court hit the nail on the head when you said, if two people have a parentage issue, where do they go? Well, the answer from counsel, and I agree, is they go to the domestic relations court. You cannot go to the probate court. So I'll just leave it at that. Counsel makes an argument that it's dicta.
But this is so circular because you also have to determine if you have jurisdiction over a step-parent adoption.
But if you go to the, see, that's the problem that I think we're having here. If you are saying, I am a parent, and you are not going under the guise of step-parent, you can only go to one court. If you come to the court and say, I want a step-parent adoption, you're saying, in essence, I have no genetic relationship or biological relationship to that child, so now I have to go to the probate court. There's a very significant distinction on where you go and why you go. And that's the problem with Judge Stormer's decision, because she kind of blends it all together. I want to touch on the issue of dicta, because I disagree with counsel. This is not dicta. Her decision says on page 1, because this court finds that the petitioner is a parent and not a step-parent, the court dismisses. The court then goes on the last page and says, the court holds that, I'll insert, appellee is one of the parents of T.D.A. That's not dicta. And contrary to what counsel says, yes, you could take this decision and take it to any court and say, I've got a decision. So I disagree that it's dicta. Third thing, when you present a pleading to the court, that's the foundation upon which the court proceeds. In this case, the pleading presented by the appellee was a step-parent adoption. What's interesting about all of that is the following. If the appellee thought that she was the, quote, natural parent, or not natural, a parent, why would she file a step-parent adoption? She didn't think she was a parent. That's why she went to the probate court. There's no other answer for that. And what has happened is, and to credit of counsel, they've kind of had like this sea change. They now have shifted from the step-parent, and they make this big argument now about the birth certificate. Here's the problem with the birth certificate. Number one, read the transcript. There's like 5 lines. Is this the child's birth certificate? Yes. There's no discussion about what Florida law is. There's no discussion and say, we want the court, probate court, to take full faith and credit. None of that exists. What has happened here, and I give counsel credit, I do, because we've known each other for a lot of years. They've seized upon a moment. That's what they've done here. Their focus was consent versus support. Now that Judge Stormer's decision to come out, they're changing their entire approach. I don't think you can do that.
And you're out of time.
I appreciate that. Thank you very much.
Thank you. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, our decisions are posted on the Ohio Supreme Court website. Thank you both for your presentations today.
Thank you.